What happens, so we have an on or about date.
Right.
And you said there's a 30-day window on that. So May 1st, on or about closing, could be June 1st.
Right.
What happens when that May 1st passes?
Well, if everybody in the transaction has been prepped properly, they understand that that's not the date for closing.
Doesn't mean anything, right?
Doesn't mean anything. I often say it's picked out of thin air. It's a target date. Mm-hmm. It's a window, and that's the first day of the window.
Yeah.
Often we can close earlier if everybody is on board. Often June 1st comes in that situation.
So what happens when June 1st? That's
New York has no penalties in our contract. So we can have an on or about date of May 1st. Everybody thinks it's closing between May 1st and June 1st. June 2nd comes, June 3rd comes. Title isn't clear, lender isn't clear, seller's purchase fell through, they have nowhere to go. Buyer had a problem, whatever the issue is, if June 1st comes and we haven't closed, I can, whether I'm buyer or seller, send what's called a time is of the essence letter to the other side,
And that gives them how much
demanding that
longer?
we close 14 days. Some people say 15, another 2 weeks.
So
And there's
we're
no penalty
40
attached to that either.
We're 44 days past our on or about date.
And there's nothing I can do if we don't close in that time frame. We do threaten to keep the deposit, but the honest answer is that no attorney is releasing a deposit to a seller if the on or about date has passed or the date in the contract has passed. Mm-hmm. It's a liability for me to do so. The contract says I had to put you on notice that I could release the money to the seller, but I'm certainly going to get sued personally and professionally, as is my seller, if I do that. The reality is you have to talk to everybody in the transaction.